there and taps his hands, and you're just sitting there, and he, sits there and rocks back and forth in the chair, and a bit of another murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Hello everybody, excited utterance here. My name's Hella and it's a Bryan Kohberger Day, Idaho 4. Welcome everyone. Important information today. Important. Everything you wanted to know about IgG but were scared to ask your parents. In fact, for Mr. Daly in chat, where do babies come from? You see, when a mummy and daddy love each other very much, or maybe if they didn't, maybe, if they just met on a street corner or something like that, we're going to find out today. And then, can the cops just do whatever they like to find out where you came from? Yes, we're going to look into that today. So, Mr. Kohberger comes now, Brian C. Kohberger. He would like everybody to know what the police did to find him, because something Susberger is going on. Susberger. But first, I would like to say hello to everybody in chat. It's like a plug in a sock. Kind of, KLF. Kind of. Sometimes no. Sometimes things happen a little differently, like maybe in a petri dish or something, who knows. You love the symphony. It's very fitting for today. Yes, indeed. It's a big day for the Americans. Hey, Chinny, how are you? Evie, I have an answer for you. You said, whatever he is, convicted, lol. Who is that woman? All right. So that is the mother of Kaylee Goncalves, or Gonsalves, I think is how you say the surname. Sorry that I get the pronunciation incorrect. Yes, that's a very contentious interview that occurred there with her and her husband Steve, and she was referring to Bryan Kohberger and her distaste for the fact that Brian at his pretrial hearings was not in orange and shackled. Now, he was shackled, of course. It just, you can't see the shackles. But she doesn't like the fact that he appears in a suit for his pretrial hearings. And she doesn't know the term for what he is at this point. She goes, whatever he is, convicted, he's not convicted. So that little snippet there, that always makes my blood boil, that little snippet, because he's not convicted. Yet News Nation allowed that little piece to go to air of her saying, whatever he is, convicted. And what's he doing there? Tapping his hands. Why is he not in orange? I get that she's a grieving mother. However, they should have edited that out. They should have edited, because he's not convicted at all. He has the right to the presumption of innocence. So that's who she is. Okay, hello, Emu Warrior. How are you? And it's good to see you, Amy Warrior. I haven't seen you for a bit. G'day from Melbourne. Indeed. And earlier in chat, Maddie B and Scott are busy talking all about Inauguration Day. Good to see you all here, though. Maddie B. Scott. Is Christine here somewhere? Hey, Christine, how are you? And Deebs. Deebs, this ish is wild. You can't wait. Well, that's cool. Good to see you, Deebs. And we'll be heading over to Ange after this, so that's cool. Mavka is here. Mum of the one he should be not guilty of, even if he did. Yeah. The Gonslavi's parents are the worst. Well, look, KLF, here's the thing. The Gonslavi's parents, I hate the fact that I feel this way about them, but they have been very well known for, let's say, raising a lot of money for themselves, and getting in the way perhaps of the other parents and their efforts to move on from their grief and perhaps raise a little bit of money to attend the trial in Ada County, for one thing, to create memorials, that sort of thing. So I'm not going to speak any more on that. But yeah, it's been tricky. It's been tricky. Let's just say that. Okay. And 20th Century Fox is here. I feel terrible for the parents, but confused. I want the truth and would think that would be especially true for families of victims. You would think, but especially the Gonslavi's family have been absolutely 100% wanting to put a bullet in Brian Kohberger's head right from the start. They don't seem to care. They don't seem to care. Yeah. Okay. I'm getting dual screened. What are you talking about? Oh, are you dual screening me? That's nice. That's nice. Hey, Laura. How are you? Good to see you. And agreed. I see them as taking advantage of the sympathy. They've made it a contest and income. Every time they appear on any broadcast, and they appear on broadcast a lot, they speak of their GoFundMes, of their gift card programs. They have a Facebook account or page that is sponsored, so you can actually become like a member of it, kind of like a monetized YouTube channel. They have raised hundreds of thousands of dollars for themselves. So look, I do have sympathy for parents who've lost their child. Obviously, I can't not have sympathy for them, but I just don't understand what all the money's about. I just don't get that bit. And the three other families do seem like decent people. Yeah, they do. It's just really weird. That's all. Yeah. Okay, so let's get into it, guys. The 23rd of January was supposed to be the hearing that we were all going to see and look forward to, because the motions of to suppress were all going to be hopefully streamed and we would see the whole thing. But that's in question right now because of this. Let's have a look. Let's have a look, and I'll put up my little overlays like I do, because you know me, I like to make things pretty. All right, so I might just swap actually to notice of hearing, this one. Okay, so this shows us that tomorrow, was it tomorrow? I'm not, okay, for me, today's the 21st, so it is your tomorrow. Tomorrow, on the 21st, January 21st at 10 a.m. Mountain Time, the court will hold a closed, sealed hearing by remote video means to 1. Hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA. So, this is important. The defense motion, let's just look at that closer. The defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA. And we'll talk a little bit more in a minute about what this IgG DNA really is, right? But the defense has put in a motion to unseal those materials, right? So they want us to see them. Us out here, little old us, right? So tomorrow at 10 a.m., this is the court saying that there will be a closed hearing, and it's going to be by remote video because a lot of the lawyers, they're back over in Later County or they're a long way away. That's fine, right? So if any and under what circumstances should the various motions set to be heard on January 23rd and January 24th be open to the public either live or by video, right? So whether or not people are even going to be allowed into the courtroom to see what's going on. Judge Hippler will decide on the 21st whether that's actually going to happen. So the clerk will provide a video link to the attorneys of record who request a link and to the Ada County Jail so that the defendant may appear via video. The Ada County Sheriff is hereby ordered to provide a secure and private space for defendant to appear by video for this hearing. It's so ordered. 15th day of January, Stephen J. Hippler. Okay, so here we go. We thought that we would get to see what was happening on the 23rd and the 24th. It's up in the air right now because of this defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA. Let's have a look at that defense motion to unseal, guys, because it's super duper interesting. It is super duper interesting. So, share this instead. Okay. So, comes now. Brian C. Kohberger, by and through his attorneys of record, and hereby moves this honorable court for an order to unseal the investigative genetic genealogy, also referred to genetic information or IgG, suppression briefing, footnote 1, and related hearing. Okay, so, and they have referenced the related briefs memorandum in support for motion to suppress and to sealed objection to defendant's motion to suppress. So there is obviously a objection there, as there usually is. Okay, so we're going to talk in a minute about what IgG is, but first let's just get through this document. A lot of people in chat will probably already know what IgG is, but I have a cool document about it that sort of puts it in lay people's terms. So I wanted to understand it a little bit better, and especially how it related to this case. So I thought it might be a good idea to have a bit of a look. Hello, Truth and Justice Crime with Anna. Nice to see you here. And Bunny Murphy. Cool. Nice to see some new people in chat. Okay. Procedural history. So Mr. Kohberger filed his first motion to compel. Oh God, that was a long time ago because there's been 6 motions to compel. But first motion to compel IgG discovery on June 22, 2023. The hearing on that matter was public and involved the testimony of several experts. I remember that. The court ordered the production, the production of records in camera and under seal. So in camera means actually the opposite, without cameras. So I love that term in camera because, yeah, it means nobody around, no cameras. And under seal, so we don't get to see the documents either. Mr. Kohberger filed a second motion to compel IgG discovery on April 15, 2024. Over the objection of Mr. Kohberger, the court required that portion of the May 30, 2024 hearing on the second motion to compel IgG discovery be closed. So, Mr. Kohberger objected, yet the court, which was Judge at the time, required that hearing on the second motion to compel IgG be closed. Right? So he wanted people to hear about it then. But Judge said, nah, too bad, so sad. Yep. Hey, Sean, how's it going? Okay. The court again ordered the production of records under seal. The court's concerns, okay, so remember this, right? The court's concerns were the privacy rights of the names of individuals identified in Mr. Kohberger's family tree. Oh dear, isn't that nice of him? At the first and second motion to compel IGG discovery, Mr. Kohberger argued that he would be filing a motion to suppress the IGG. Oh, that's okay. So he asked the court to allow the pleadings and hearing be public. Okay, so two different things. So there's the exhibit, which shows the family tree and has the names in it. And he said, okay, fine, we'll put that under seal. That makes everybody happy. We're not mentioning any names. But I want to have the court hearing about it to please be open to the public. Thank you. Please, can that be open to the public? Right? That's what happened then. On May 20, 2024, the court indicated it would take the matter up after the suppression pleadings were filed. In the interim, the venue changed, so some time passed, the venue changed, and this case is now before a new judge. The motion to suppress genetic information was filed on November 14th, 2024, and is now fully briefed. Pursuant to court direction, the parties stipulated to file all IGG suppression pleadings under seal. Right. So deciding between both parties just to put the pleadings under seal is not the same as putting the actual evidence under seal. It's just the pleadings. Right. So the arguments between each other. Different thing. No names of the extended family tree are discussed in the briefing. That's important because remember, that was the court's problem in the first place. The matter is set for hearing January 23rd and 24, 2025. It's what we've all been waiting for. Mr. Kohberger requests that the briefing be unsealed and the hearing take place in an open court. Mr. Kohberger wants that. Now, isn't that interesting, right? And he wanted that back in May, remember? He wanted that back in May. Argument. Now, this is where it starts to get interesting from a point of view of someone in the public who is interested in the case, interested in the rights of a citizen who has been arrested potentially on evidence that's been collected from a public database of genetic information, right? So stuff that people upload to things like 23andMe. Due to national and international attention to this case, and in the interest of protecting Mr. Kohberger's right to a fair trial, many pleadings in this case have been sealed appropriately, pursuant to Idaho Administrative Rule 32. Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of this right to a public trial. Now, isn't that interesting, right? Sealing a suppression hearing is a clear violation of this right to a public trial. I remember when Andrea came on here and we were talking about this hearing on the 23rd, and this was 2 months ago now. And I said to her something along the lines of, do you think that this is going to be an open hearing on the 23rd? And she referred to suppression hearings needing to be public. And I wondered what she meant. We kept talking about something else. This must have been what she was meaning. And I don't mean to put words in her mouth, but this is very relevant to that conversation I was having with her. So Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of this right to a public trial because it's a suppression hearing, right? So it's about suppressing evidence. So how can you seal it? How can you make it so that you're sealing discussion about something that is already hidden? So you're hiding talk about hiding something. That seems to be a bit sus, right? Tell me if I'm wrong here, right? Shibbles, how are you? Okay. See Weaver versus Massachusetts, Waller versus Georgia. Sealing of motion to suppress to protect privacy of witnesses was error, requiring remand for new public hearing. State versus Ingram. U.S. Constitutional Amendment 6, Idaho Constitution, Article 1. Wow, they have a lot of case law on this. A lot. Like 5. Okay. In addition to Mr. Kohberger's right to a public trial, the public has a First Amendment right to know what goes on in its courts. State versus Clapp, 2020. Idaho Code 74-104B recognizes that records contained in court files of judicial proceedings may be exempt from disclosure under rules I can't say that word. Promulgated by the Idaho Supreme Court. The Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied. State versus Doe. I wonder whether that's John Doe or Jane. Could be either. Pomegranate. Okay. When the court is considering whether to seal the record, Rule 32 directs the court to consider the traditional legal concepts in the law of the right to a fair trial, invasion of privacy, defamation, and the invasion of proprietary business records, as well as common sense respect for shielding highly intimate materials about persons, ICAR 32.1.3. Under Rule 32, I3. I1, records may be sealed or redacted if the court determines and makes a finding of fact as to whether the interest in privacy or public disclosure predominates. The court's decision to seal judicial records is discretionary. Doe 153, Idaho 687-290 P3D at 1279. Okay, so the court can decide whether or not to do this. However, they have to have a pretty good reason. That's what I take from that. Hello, woman. Woman. Yes, it is good morning for me. It is. And if you want to buy me a coffee, anyone in chat, that is, there is a link at the top of chat. You'd be very welcome to. Why, thank you. Sean is already a member of my coffee club. Thank you, Sean. Love you, woman. Woman is always just doing just the tip. Just the tip. And oddly enough, we're talking about tips today. I'm going to get into it soon. Here, the way in which IgG material was accessed and used is a matter warranting public disclosure and should not be shielded from the public's right to know. This is what this is about. Okay, so this is why Mr. Kohberger wants this information to be unsealed and for there to be a public hearing about it, because he's saying that the way in which, I should have highlighted that, the way in which the IgG material was accessed and used is a matter warranting public disclosure and should not be shielded from the public's right to know. He's saying there's something sussy about the way law enforcement access this IgG material. And this comes down to whether or not there's a domino effect, guys. So you know all those motions to suppress we were looking at in the last stream. In fact, I can even, if you want, I can even show you all those motions to suppress. Hang on. I'll just change over. There we go. Show this tab instead. Yep. So we've got motions to suppress, motion to suppress. Oh, these are the state's objections, but it doesn't matter. You can see them all. Look at all these motions to suppress, right? The reason there's all those motions to suppress, there's other reasons too, but the IgG search is listed in all of those motions to suppress because they are fruit of the poisonous tree. Fruit of the poisonous tree means that if that IGG search was done illegally, none of these things are legal either. So that is the warrant for the apartment, the warrant for the Apple search, the warrant for his arrest, the warrant for his cell phone search, for the Elantra, for the search of his body, for the pen trap and trace, etc. Right? So this is so important to the state. If they lose on this, they lose all of it. Everything. Gone. Case gone. Hey, Truth and Justice, True Crime with Anna D. I bet you law enforcement went to a site that does not let Ellie put in profiles. Maybe. Maybe. And that's the thing. We should know. And that's what would come out in this hearing if we get to see it. If we get to see it. If we don't get to see it, we'll never know. Right? We will never know. Even if it was determined it was legal, it was still done illegally, most likely. Yeah, I mean, there could be some loophole there to make it legal. All right, but I'll show you something in a minute about how IGG is supposed to be used as far as the Department of Justice is concerned. And yeah, you tell me what you think. Okay. It's a really new area, this, and generally it's used for cold cases or for finding the identity of victims, not for finding a suspect. So we're kind of in uncharted territory with this one. Okay. This matter is of utmost importance to Mr. Kohberger's right to a public hearing. Holding the hearing in open court will not prejudice the parties. That's important. Right? It can't prejudice the parties, and this should be held in open court. The issues raised are legal issues, and cases with similar issues are being decided in other states. The issues raised in Mr. Kohberger's suppression motion are those that were discussed in the public hearing on the first motion to compel. Additionally, hang on. In the first motion to compel, and there is a footnote number 4. Aspects of the IGG investigation in this case have already been leaked. Guys, this is a huge footnote. It's so funny that the footnotes hold the most information in these documents. Aspects of the IGG investigation in this case have already been leaked. Heather Towle Murphy, how police actually cracked the Idaho killings case, slate January 10, 2023. So only months, weeks after the killings. So not very soon after he was arrested. This article came out, and I will show you it. Here it is. How Police Cracked the Idaho Killings Case by Heather Towle Murphy. Investigators used forensic genealogy to zero in on suspect Bryan Kohberger, but they aren't saying so. Isn't this interesting? Right? So this information has been out there right from the beginning, in the public forum. Look. Now, I think I've highlighted something down here. No. Where is it? Early on in the investigation, the Moscow Police Department became interested in a white Hyundai Elantra that surveillance footage had captured near the house that morning. Police compiled lists of white Hyundai Elantras spanning from 2011 to 2016 that were registered at local universities and instructed officers to search for still more. An affidavit released last week revealed that on November 29, just 2 weeks after the crime, these techniques succeeded in identifying a 2015 Elantra registered to Brian Kohberger, a 28-year-old criminology student at nearby Washington State University, and yet it would be another month before police arrested Kohberger and charged him with the murders. All the while, investigators would keep pleading for more tips about Elantras. That's because it was not Kohberger's Elantra that had elevated him to a priority person of interest. Rather, according to a law enforcement source familiar with the investigation with whom I spoke, a key reason police focused on Kohberger as a likely suspect has to do with something that is never mentioned in the 18-page affidavit, forensic genealogy. It was only after investigators utilized a technique reliant on genealogy databases to determine who'd left DNA on a tan leather knife sheath that police requested a search warrant for Kohberger's phone records. According to this source, up until that point in late December, he hadn't stood out among all the other Elantra owners, and there are a lot of Elantra owners. The source said, something that is reinforced by a close, informed reading on the affidavit. Now, someone's name, here it is. Someone's name stood out to me. Tiffany Roy, here. Yeah, the article, you're right, CH. The article does make some crazy statements, but I was really interested to see Tiffany Roy mentioned there. I know of her. Steve Gosney knows of her. Solomon Anderson knows of her. She is very credible. She wrote a complaint to the Department of Justice about the DNA testimony in the Zachariah Anderson case. And this is what she had to say about this. The use of forensic genealogy also underlines that the current storyline about how police identified their suspect, which some are suggesting is a model, is missing pivotal details. According to numerous genetic genealogists, the case embodies an emerging trend of leaving out any mention of forensic genealogy from court documents and press conferences. The Idaho affidavit's thoughtful omission of any reference to genealogy, as forensic DNA analyst Tiffany Roy puts it, has reignited a heated debate among investigative genealogists, lawyers, detectives, and other forensic experts about the wisdom of this strategy. Now, I'm going to try and get in contact with her. I think I can. That was 2 years ago. That really interests me because this aspect of it is clearly very secretive on the part of law enforcement. Yes, as she said, it was a thoughtful omission, right? And it's been kept under seal, and there's all this stuff about wanting to protect people's identities and smoke and mirrors approach to how they found Brian Kohberger, right? And I don't like it. Lots of people don't like it. And as Brian Kohberger says, the public has a right to know. The public has a right to know. So we'll come back to that in a moment. Let's finish the document. So yeah, you're right, CH. I'm not going to go through the whole document. A lot of it is not that relevant, but I found that bit to be credible. I know who she is. And yeah, when I saw her name and what she said, that really stood out to me. Okay. Also, additionally, the way in which IgG occurred in this case has been made public in other cases. See State versus Hartman, 534 P3D, the ingenious and dystopian technique police used to hunt the Golden State, that should be State killer, suspect, Washington. Right, okay, with the Golden State killer, that'll come up in a minute. So I'm going to talk a bit about IgG shortly. In fact, yeah, it's probably the most famous case that's used IgG to identify a murder suspect, and it was a cold case. So cool. Yes, that's a big deal. Mr. Kohberger has a right to a public trial, and the public has a right to know how genetic information was used in this case. Now, importantly, neither the state nor Mr. Kohberger will be prejudiced by unsealing the briefing and holding the IgG hearing in an open court. Right? So the pleadings and hearing should be unsealed. Okay? So, I mean, they make a bloody good argument. They make a bloody good argument. And I don't know when we're going to find out the result of this hearing. So the hearing being the 21st, it is, what did they say, 1:30 p.m. Mountain Time. And the result is going to determine what, if any, as they've said, I'll show this instead, consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24 be open to the public, either live and or by video, right? So you saw all those motions that were supposed to be argued. The court is putting it all up in the air, whether or not any of it gets to be seen by us. Hey, Fungian, how are you? Okay, so I want to talk a little bit about IgG because it was blurry to me. It's still blurry to me, obviously. I am not a scientist. Sure, there's few of us in here who are, except AG. But I just wanted to do a little bit of research on it because, and I found a lot of articles, obviously, but this one stood out to me. And this one's aimed at prosecutors. Hang on, I'll share this tab instead. This one's aimed at prosecutors. Great. Investigative Genealogy, a guide for prosecutors. Yes, you, AD. You. Yes. Okay. So, a guide for prosecutors. So, Forensic Investigative Genealogy, abbreviated FIG, IG, or FIG. I'm not going to read the whole thing, by the way. I've highlighted some bits to sort of show you, and it's long. So, but I might put the link in chat for you if you are interested in reading the entire thing. Cool. Okay, is a groundbreaking tool in the field of criminal investigations. It is revolutionizing the way DNA evidence is utilized while giving law enforcement the confidence to solve previously unsolvable violent crimes. Reflecting this confidence and enthusiasm, one investigator remarked, I truly believe that this is the new fingerprint. It has resulted in identifying suspects in tricky cases that could not be solved in any other way. A seasoned genetic genealogist explained... Oh, sorry, that wasn't the prosecutor. I was just doing a generic prosecutor's voice. In case after case, the comment is, that person was never on our radar. I'm going to read that bit. Okay, so what is IgG? IgG is an innovative investigative approach that combines traditional genealogy with advanced DNA analysis to solve crimes. Fig Jam. Okay, only Aussies know what Fig Jam is, apparently. Apart from the fact it is my top-level membership, if you want to become a top-level member, just go to my member tab and support an Aussie. And then you'll find out what it really means. It is transfer DNA, yes. And we're going to talk just a tad about that in a minute. I'm working on a video about what transfer DNA is, actually, Fondian. But we are going to talk just briefly about the transfer DNA effects in this live. Okay, fine, I'll tell you. Fuck, I'm good, just ask me. Anyway, let's get back to this. IgG is an innovative investigative approach that combines traditional genealogy with advanced DNA analysis to solve crimes. The technique is primarily used on cold cases, but the future of many criminal investigations that are not initially solved may be based in the world of IgG. This article will give an introductory overview, blah, 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 blah. Okay, so the Golden State Killer, there we go. Golden State Killer comes up. Yes, touch DNA is the same thing as transfer DNA, Eric Foams. IgG isn't touch DNA. No. Okay. So, Golden State Killer. Even after 5 years, it's impossible to discuss IgG without mentioning the Golden State Killer, the GSK. A prolific serial killer in California during the 1970s and 1980s who was responsible for at least 13 murders and 51 home invasion rapes. This high-profile cold case was solved using IgG. Okay, so basically what happened was it was a cold case. They had lots of other clues, but they couldn't find the person. They had some really old DNA, but you guys know what CODIS is? CODIS is like the registry of DNA, right? So this guy that they end up finding, he wasn't in CODIS, right? So they couldn't backwards match his DNA to anything they had in a database. And that's really what they're using this for, okay? So usually if you have DNA and you're trying to match it to something, you're matching it to people who have a previous conviction, right? Or a previous arrest, and they take the buccal swab and they keep that person's DNA on file. And that file is CODIS, C-O-D-I-S. The GSK killer wasn't in the CODIS database. So also, it was a very old case, so I don't even know if CODIS exists back then. DNA technology didn't exist back then. So they had nothing to match these samples with. What are they going to do? So they go and use IgG, which we'll talk about in a minute. They blur on for a bit. Okay. Now, DOJ's interim policy for forensic genetic genealogy. Before proceeding with the type of forensic testing required for IgG, SNP is another thing that gets used and thrown around. Single nucleotide polymorphisms, pronounced SNP testing. I should stress that law enforcement should follow the Department of Justice interim policy for forensic genetic genealogy, DNA analysis, and searching. It is critical for all agencies involved in an IgG investigation and prosecution to communicate with each other to ensure they are not risking federal grant funds by violating the policy, as federal law enforcement agencies and those receiving federal funding for IgG must follow the policy. Plus, its protections and procedures are in place to balance the interests and privacy rights of the public. Yeah, I would think probably it would mean that your evidence is inadmissible at trial as well. Just guessing. Okay, so there are some exceptions for violent crimes, see? So the policy is clear that IgG is an investigative lead technique. It's a lead technique, right? So it's not evidence. It should be used for identifying suspects only in violent crimes. So the Idaho 4 case would be a violent crime, so tick. Murder, attempted murder, sexual assaults, as well as for identifying unknown human remains. The policy requires law enforcement to get prosecutor concurrence before using IgG. There is an exception to the violent crimes requirement when it concerns a matter of national security or if there's an ongoing threat to public safety, blah, blah, blah. Okay, so that's fine. In the policy, prosecutor refers to Assistant Attorney General. Yeah, that's fine. Okay, so I went forward a little bit here. This bit. Okay, so if anyone has ever used something like Ancestry.com or 23andMe, you would probably have clicked something that, and you might not have read it, but you would probably click something that has like an opt-in or opt-out of your use of your information for law enforcement searches, or I'm not sure of the exact wording, but there is like a public access search. It's an yes, Laura, it's an investigation and lead tool. It gives them suspects to look at. Yeah, absolutely. Right. So law enforcement must only use public genetic genealogy databases. Yeah, okay. So that means people who have opted in to allow their DNA information to be public, right? So we could have a problem there. There could be information that has been searched that is not public. That could be what Mr. Kohberger is talking about. Perhaps. Don't know. Who knows? Who knows what it is that he's saying that they've done that's illegal? We're about to find out. Well, are we about to find out? That clearly state in their terms of service that law enforcement and the public at large may access their data. Informed consent from individuals who submit their DNA profiles into IgG databases is paramount to protect the important privacy rights and ethical concerns of millions of innocent third-party citizens. All uploaded personal genetic profiles and service account information shall be treated as confidential government information. Finally, law enforcement is also required to get informed consent from third parties before collecting any reference samples used for IgG. I suppose informed consent means that they have clicked the button, I guess. Okay, so this policy also stipulates that IgG results serve as investigative leads only. So it's a lead. Suspects cannot be arrested based on IgG results alone. Now, this could be the thing too, right? If he was arrested before there was other evidence sufficient for his arrest, that could be a problem, right? So a direct STR DNA profile comparison is necessary. Additionally, cases investigated using IgG should be entered into the FBI's VICAP, Violent Criminal Apprehension Program. It's an investigative lead. It's not enough for an arrest, right? So I'm just looking at, based on all of this, what could be possible things that Mr. Kohberger is saying they could have done that could lead to a motion to suppress or a reason to suppress this evidence because they did it illegally. And they've been saying it all along, right? This is not new. This is since June last year, right? So June 2023, oh, not last year, the year before now. Since June 2023, the defense has been saying that this IgG search is illegal. Right, and they've stuck to it, and they've also been saying, they've been saying that the public needs to know about what law enforcement did with this IgG search, right? So what is it? I'm dying to know what it could be. Let's go down a little bit. This is a long article, but I went a little bit further. All right. Suspect identified. Right. So once your suspect is identified, in IgG cases, law enforcement often narrows down the suspect pool to a small group of blood-related individuals, typically siblings or first cousins. Investigators then meticulously examine each suspect until they obtain a direct STR DNA confirmation necessary for an arrest. Hey, American Princess, how are you? Necessary for an arrest. The initial focus should be on the suspect most likely to have committed the crime based on available evidence. However, the most apparent suspect is not always the perpetrator. No. Multiple cases have required law enforcement to collect surreptitious DNA samples from various suspects before identifying the correct match to the crime scene evidence. Surreptitious, eh? Let me just wait behind you at the restaurant and get your napkin, shall I? The DOJ interim policy is clear. A suspect shall not be arrested based solely on a genetic association generated by a GG, genetic genealogy service. If a suspect is identified after a genetic association has occurred, STR DNA typing must be performed and the suspect STR DNA profile must be directly compared to the forensic profile previously uploaded to CODIS, assuming one exists. This comparison is necessary to confirm that the forensic sample could have originated from the suspect. Right, so in other words, once they have the match or close to match, then they need to get a swab from the actual person and compare it to the sample that they have from the crime scene and be sure that they have a match. Now, we'll talk in a minute about the DNA that they have at the crime scene, because that is transfer DNA and that could have got there anyway or anyhow, but that's a different story. In most scenarios, law enforcement will obtain a suspect's STR DNA profile using a surreptitious collection method. The most common of these is the trash pull. Well, there you go. The trash pull. Hey, Twizzle's here. Hey, Twiz. Twiz, you're from Ladar County, aren't you? This is from your neck of the woods. Well, the trash pull didn't happen in your neck of the woods. It happened in Pennsylvania. I am never putting my DNA anywhere near one of these databases ever. Ever, ever, ever. And I'm telling everyone in my family never do it. My mum would, though. My mum would. Garbage pull DNA is legal if it's done legally. If it's done legally, there is a curtilage issue potentially. I don't pretend to understand it properly. In the gated community where Kohberger's family lives or lived. I don't know if they still live there. So I say curtilage, I mean where the trash was stored up near the house, like in the garage kind of area. So the initial trash pull could be the issue. Oh, you live in Pullman. Sorry. Pullman. Good to see you, Twizzle. Okay. All right. Well, I don't know. I'm Australian. I live in a fake country. Dear. Okay, so trash pull. It is critical that law enforcement follow all local, state, and federal laws when doing a trash pull. See, here's the deal, right? So if they didn't, let's just assume they didn't. We have an absolutely clear reason to suppress that evidence. And remember, domino effect. If that evidence gets suppressed, if that warrant is, if that search is deemed to be illegal, fruit of the poisonous tree, everything else falls down. Brian Kohberger goes home. Motion to dismiss, goes home. Chances of that, because there will be some technicality. Something will give. Something will give. Maybe it was taken like we would take being called a North Sider Helen. Yeah. Maybe. Twizzle, this is what the defense has been saying all along, right? They've been really clear all along that the IgG was found, he was identified illegally by this search, by this IgG search, right? They've been saying it all along, and they've been trying to make it public all along, right? So this hearing, if it's not public, obviously we're not going to find out what that's all about, but it's on record several times now that the defense has tried to make it public. So that's why so many people, among other things, but one of the main reasons so many people are so sus on what's happened here, it's because it's very unusual for a defendant to be like, bring the evidence out against me to the public, please, right? There may be a suppression order, fine, but I want that bit to please come out to the public. Everyone has a right to know what you guys did to me, right? So people want to know, they deserve to know, so spit it out. There's no prejudice to either party. You can suppress people's names, it's fine, right? What do you got to hide, state? Freaking put up or shut up. Come on, show us your cards. Same with the cell data. Same with the cell data. Except here's the thing, Twizzle. I think that the FBI has the cell data, and they ain't handing that over. I don't reckon the state's got it. Yeah, well, if I'm guilty, show the world why. If I am, show us what you got. All right. Okay, so the DOJ interim policy also requires prosecutor concurrence to plan and execute a trash pull for IgG. Failure to follow the law at this point can jeopardize the STR DNA testing. Law enforcement will need probable cause to make an arrest, and IgG should never be used as a probable cause for an arrest or search. It should be treated akin to an anonymous tip. In legal terms, guiding investigations but not serving as a basis for probable cause. Well, they never put it into the probable cause, so I wonder why. A quick refresher on anonymous tips from Davis versus State. Yeah, that's fine. Okay. IgG at trial. At trial, nothing changes. The prosecutor should not present IgG investigative evidence at trial. Right, so that answers some questions. That is why the state never wanted to put the IgG up at trial. Of course they didn't. That makes sense. The evidence the prosecution will use to identify the defendant will be the buccal swab STR DNA confirmation testing that was taken subject to a search warrant or consent at the time of the defendant's arrest, right? So that's all they're interested in, showing that he actually matches the transfer DNA that is on that sheath. That they won't explain that it's transfer DNA or what that is. Yes. It's important to note that just because IgG evidence does not need to be admitted at trial, IgG evidence must be turned over in discovery. Boom. There may be situations where pretrial hearings on IgG evidence and IgG discovery are warranted. Law enforcement must preserve all relevant communications, notes, tree building records, relevant matches, and SMP testing results, and maintain regular communication with prosecutors about the IgG evidence. That's pretty important, because it's discoverable. Hello, that's discoverable. That's how you got it. That's like your working files. Remember Mowry? Anyone who's been following this, remember Detective Mowry, right? And how like he was building the cell data maps, and he was using some version of the CAST software, and he didn't save his work. He just used Windows snipping tool. I use Windows snipping tool. Seriously, bruh? Bruh. Okay. All right, that's probably enough there. So, you see, I probably brought up maybe 3, 4, 5 different potential reasons why this search could be unlawful. The most likely reason, and that has been alluded to several times throughout the documents and in the hearings, is this trash pull. If the trash pull was illegal, then the results of the IGG, or the search of the IGG, would therefore be illegal. The map was all that mattered, right? No need to know how it was made. Yeah, exactly. Exactly, yeah. I use window snipping tool. Exactly. Okay, I want to talk, before we finish this up though, I want to talk just briefly about this touch or transfer DNA. Okay, and I'm going to make a separate video about this because this bothers me greatly. And it's come up in several cases. The one closest to my heart is Zachariah Anderson. He was convicted on a pinhead of transfer DNA in the back of his van, which the prosecutors told the jury that it was blood when it wasn't blood at all. There was no evidence it was blood. It just looked like blood, but therefore, but there was also a lot of other stains in that car that looked exactly the same, and they weren't blood. So the secondary DNA transfer, the rarely discussed phenomenon that can place the innocent and the dead at a crime scene they've never been to. This is so important because here we have DNA that absolutely is of that person, right? There's no argument that that DNA that they found via IgG, and then they took a buccal swab of Mr. Kohberger and they tested it back to whatever was on that supposed knife sheath that they found. It's his, right? But transfer DNA doesn't mean he was there or that he even touched that thing. It's a huge, huge problem, and there's probably thousands, if not hundreds of thousands of people sitting in prisons right now who are wrongfully convicted because of this problem. It's a massive, massive, massive problem, right? Hey, Ange, how's it going? How's it going? Okay, so, have DNA will travel, right? So this particular article, I've had it for a little while, but this is all about the dark side of forensic DNA. So when you consider that over 10,000 cells fit on the head of a pin, it becomes clear that the days of testing only large visible stains are long past. While forensic scientists have become highly adept at confirming an individual's identity through analysis of microscopically small samples of biological material, little attention has been paid to a question that is equally important to the origin of DNA found at a crime scene. How did it get there? Prior to the late 1990s, the universally accepted answer was the originator of the DNA left it at the scene. That's what has made DNA evidence the magic bullet that all forensic investigators hope to find. Now, sorry that it was an Australian forensic scientist. Oops. But, however, a potentially explosive problem was discovered in 1997 when an Australian forensic scientist, Roland van Oorschot, published a short paper titled DNA Fingerprints from Fingerprints. The paper detailed Van Oorschot's findings that DNA can not only be transferred from person A's hand to an object, referred to as primary or direct transfer, but person A's DNA can also be transferred from the touched object to person B's hand. So this phenomenon, known as secondary DNA transfer, introduced a significant wrinkle into the world of forensic DNA analysis. Oops. Murphy referred to a primary transfer as the engine that turns the wheels of justice and a secondary transfer as the cog that causes the wheel to grind to a halt. When we acknowledge that a person's DNA can be found on an object that he or she never touched, we come face to face with the new reality of DNA analysis. DNA may be incontrovertible evidence of identity, but DNA does not by itself explain how it got to where it was found. No. Now, importantly, there has been an unconscionable lack of interest among forensic scientists to study secondary transfer. This is scary, this part here. Kale conducted an experiment in which people exchanged 2-minute-long handshakes immediately prior to handling individual knives. When each knife was tested, the DNA of the person who handled it was unsurprisingly found in almost every case. However, the test also found the DNA profile of the person who never touched the knife 85% of the time. Perhaps even more shocking was that 20% of the time, the non-touching person came back as the primary, and in some cases, the only contributor of DNA. Just let that sink in for a minute. Hey, Steve, not Devil's favorite. How are you? Angel, not Devil's favorite. How are you? Yeah, and hey, Anne, tell you, mate, this is scary. This is so scary. And yeah, it doesn't matter if you follow this case much. This could happen to anybody, right? So you shake hands with somebody and then they touch a knife and the knife is left at a murder scene. And in 20% of the time, the non-touching person came back as the primary and in some cases, the only contributor of DNA. The only contributor, right? You're the only one with DNA on that knife. What the hell? What the hell? Right? And what if you happen to drive a white car that was just in the area? Moscow, where these 4 people were stabbed, it's a small area, right? You know how many Elantras there were? White cars similar? A lot. Mavka, only if you interact with people. Yeah. Yeah, you can just stay inside. You can just stay inside. We need to all wear rubber gloves forever. Well, that's part of the evidence against him, right? The dude was wearing rubber gloves when they arrested him. They waited until 2 a.m. and they were watching him. They had snipers outside his parents' house in Pennsylvania. They were watching him through the windows. They waited until he had freaking dish gloves on, right? So they could arrest him and say he had dish gloves on, right? And they didn't say dish gloves, they just said gloves, right? Rubber gloves. Oh, what innocent person wears rubber gloves all the time? Right? What bullshit is that? What bullshit is that? Yeah? Because the person that was seen in the house had gloves on. Guilty. Right? Snipers. Snipers. How do you say snipers, Deeps? How do you say snipers? You don't know what dish gloves are? Washing up gloves, you know. The things you use to wash up. And yeah. Okay. I don't know, what do you guys call it? Can you do an American accent for us? Sure, I'll read the next bit. It's scary, said Kale, the lead forensic DNA analysis at Strandier Diagnostics. Analysts need to be aware that this can happen, and they need to be able to go into court and effectively present this evidence. They need to school the jury and the judge that there are other explanations for DNA to be there. You like that? Parallel construction. Haha. Yes, that did occur. Right. I love that term, parallel construction. Parallel construction means that you are developing your case alongside this evidence that you've got that you can't use in court. Right? Love that term. And you're doing it in such a way that it is legal. Okay, so you might have this evidence that you can't use. So evidence that you can't use in court is IgG, right? But meanwhile, you're developing your case alongside it, so parallel. You're constructing your case in parallel, and you're finding out all this other information which shows that he is the perpetrator. Right? Yeah. So, in other words, it can be retrofitting. It can be retrofitting. Depends. Sometimes it's for real. Sometimes it's just confirmation bias and retrofitting. In reality, the prosecution and its DNA expert witness will almost never proactively explain the possibility of secondary DNA transfer and that it could potentially explain the presence of incriminating DNA evidence. Accordingly, it is critical for all criminal defense attorneys to have a firm understanding of secondary DNA transfer and be capable of challenging the prosecution's expert witness on the DNA evidence. Right? You like? Really? It's a 1940 secondary. Okay, so this is really important, right? So in reality, the prosecution and its DNA expert witness will almost never proactively explain the possibility of secondary DNA transfer. Have you guys ever heard prosecution explain secondary DNA transfer? Ever? No. And also, as Andrea said when she came on here, and I've had other lawyers come on here and say the exact same thing, jurors do not believe expert witnesses from the defense. They just don't. They see them as hired guns. They just don't. They barely believe anything that the defense puts on, but especially expert witnesses from the defense. I sound like Butters from South Park. God. Oh, guys, try and do an Australian accent. It's really hard. And I really struggle with the American accent. I can only really do, that's kind of a southern one. The southern one's the easiest one. I would struggle with, I can't do a Boston one. I can just do sidebar. No, I can't do that. No. Was that a Brooklyn? Really? That voice with a Brooklyn accent? No, I can't do that. You've tried, Steve? It's really hard. I do declare. All right. This. Okay, get ready for this, guys. Get ready for this. Other researchers have confirmed secondary DNA transfer, and study results highlight the need for a greater understanding of this insidious phenomenon. Consider the following. In another Van Oorschot experiment, 50% of a group who shared a jug of juice but did not touch each other wound up with another's DNA on their hand. In a 2016 study, British forensic researcher Peter Gill found DNA on 75% of his lab's crime scene tools, including cameras, measuring tapes, and gloves. Researchers have found that DNA can transfer it through non-intimate contact from the hands of one individual to another person's peen during urination. What? Researchers Graham and Rutty found that in more than 50% of individuals tested, someone else's DNA was on their neck. Researchers have found that 1 in 5 people have traces of someone else's DNA under their fingernails. Why are you guys holding each other's legs? Right. Well, that's clearly the question you would ask, right? Why? Excuse me, sir. Why are you holding another man's wang? Officer, get your hand off my penis. A 2016 study out of Canada found that a father's DNA is often found on his daughter's clean underwear. And in some cases, a fragment of his sperm is there as well, presumably from the mixture of laundry in a washing machine. What the goddamn hell? Yeah. Yeah, I don't know. And this is why I wanted to see, I was asking that question yesterday in your chat about was the DNA in the crime scene transfer DNA. I know some of it wasn't, and some of it was. And because Andrea made did a tweet about a week ago, when a little bit more before she went off grid, and said, "Isn't it interesting how transfer DNA is really important in Idaho, but really unimportant in Delphi?" And I found that very interesting because she's right. This is the kind of DNA evidence that law enforcement can just decide whether to include or not. Yeah? You can just, you can make a really, really big deal of it, or you can just go, if you feel like it. Yeah? So you can put someone away for life. You can put them to the death penalty because of this existing. You can bamboozle a jury with this. So easy. Or you can decide to ignore it and go with the guy that you want to go with, like Rick Allen. Yeah, like with everything else with Ellie. Yeah. Yeah. A study published in the International Journal of Legal Medicine found that a person could transfer DNA from a cloth that had been rubbed across someone else's neck onto an object that he or she never touched. Well, isn't that interesting? Like maybe a snap on a leather sheath? Maybe? A more accurate understanding of DNA transfer is leading some forensic scientists to urge caution when using such evidence in court. Latham said DNA transfer and contamination issues need to be carefully considered by scientists and attorneys and must be properly explained to juries. Hey, wouldn't that be good if it was properly explained to juries, right? Wouldn't that be good? But nothing gets properly explained to juries. All that gets explained to juries is what the prosecutors want them to hear. That's it. In Zach's case, all that got explained to the jury was there was DNA of the victim found in the back of Zach's car. Right? That's it. And they made it sound like there was blood. In fact, closing argument, the prosecutor said there was blood of the victim found in the back of Zach's car, which is a fucking lie. That's a lie, flat out. Right? And that DNA of the victim, it was never even proven with figures, like 1 in 1 octillionth or whatever we usually hear from DNA experts. It was never proven in figures that it was even the victim's DNA, but assuming that it was, it could have gotten there through transfer from the girlfriend or one of the children, or even from one of the lab techs. It was a pinhead. If a 300-pound man was in the back of that van, there would have been a lot of evidence of him being there, bleeding all over the damn place. Right? This sort of evidence should not be allowed into court. It shouldn't. The only DNA evidence that should be allowed into court is proper, is it, AG, tell me if I'm wrong here, but is it serological DNA evidence? So an actual piece of fluid or skin, like a swab, for example, transfer DNA should not be allowed in. I believe America is one of the few countries, if the only country, that allows it in to court. Steve, don't put people in Indiana down. I think it's everywhere. I think that juries are really really able to be swayed. So I don't think it's just your state. I think people believe what they hear, and they trust law enforcement, they trust prosecutors. I'm really mad at that jury. I'm really mad at that jury for not looking properly at the crime scene and not overlaying the testimony that the state put forward from Richard Allen's own mouth that did not align with that crime scene. I'm very mad at that jury. That said, I think it happens in all states. I think it happens everywhere. Okay. The curious case of the man that wasn't there. Yeah, that one goes for a while. You have a read of it if you want, and I can provide this if anyone's interested. Did I highlight anything else? Let me see. The future of DNA analysis. Just get rid of transfer DNA. How about that? That would be great. Yeah, I'm going to make a little short video about transfer DNA, but also how it was used in Zach's case, how it wasn't used in the Delphi case, and how it is being used in the Kohberger case. Oops, I need to get rid of my overlay. Cool. How it is being used in the Kohberger case. And also I'm going to include some snips from some times that I've had several lawyers on this stream, or I've appeared on other streams with some lawyers who have commented on this and said something similar to what I have just expressed, and that is that this sort of evidence just shouldn't be allowed in. It just should not be allowed in. There are probably, well, definitely, there are hundreds of thousands, more than likely, of innocent people sitting in prisons right now, or jails right now, who are wrongfully convicted because of this ridiculous junk science. It is junk science. And more people need to be made aware of it. Scientists, expert witnesses should be standing up and pushing back at prosecutors who are using it. And in potentially on a live stream, I'm hoping to get Tiffany Roy, who is the lady who was quoted in that article, cited in the motion to unseal the IgG evidence. Tiffany Roy is a forensic specialist, DNA forensic specialist, who did write a complaint to the DOJ in regard to the testimony in Zach's case, and she has commented, I've just found out that she has commented on the use of IgG in Brian Kohberger's case. So yes, I'm hoping to get hold of her. I'll see if I've heard back. No, not yet. But yeah, I'll keep you updated with that one as well. Excited utterance. I believe it's pronounced like Patrick Roy's surname. I don't know. Roy. Who's Patrick Roy? I'm an Australian, Mavka. Roy, Ray. Oh dear. All right. Hey, Judge Jessica, how are you? All right, I'm gonna dump you all over into Ange's chat. I don't know when you're starting, Ange. Oh, wow. I don't know. I think it is Roy, because I've spoken with Steve about it. Steve is a good friend of hers, and he's never corrected me. So 8:30. You guys can hang out in the chat for a bit. That's all right. Keep going. No. Keep going. Never stop. People will come see you anyway. But yeah, everyone who's usually in my chat, make your way over to Ange's and make sure that you hang out. What are you doing today, Ange? What are you doing today? What's your stream about? Let me have a look at what I am redirecting to. You're clowning on the prosecutor. Oh, that's fun. Oh, he did an interview? Did he? Did he? Oh, that's fun. Okay. Nikki babe. Nikki babe. Slicky Nikki. Oh, sweet. All right. Now you guys, you need to go over and hang out with Ange and Deeb for that. So definitely. Oh, you found the interview? Sweet. All right, good. Okay, yeah, we are going to redirect over to there. Everyone say hello, Raid, when you go over there. Thanks, everyone, for hanging out. Keep an eye out. As soon as I find out what's happening with the hearing on the 23rd, I'll post something on Twitter and in the Discord. Anyone who is a member and you're not in the Discord, do it. Do it. It's underneath. It's underneath the membership tab and perks. When is Scott's Cross? Oh, you mean, is you, Scott, you, and now I know why that. Maybe tomorrow? Don't know. Yeah, I will teleport you. Yeah. Maybe tomorrow. I might do a Melody stream tomorrow. We do Melody Farah streams in between when there's nothing really important happening and we have a really great time. So yeah, I might do Scott's Cross tomorrow whilst we're waiting on the Kohberger stuff to happen. Because once Kohberger happens, assuming that there is a hearing and we can see it or documents, we'll be Kohbergering. And with Nick McClelland's interview, I might have a look at it, and after Angie's done making fun of it, I might make fun of that too. So, guys, go watch Ange make fun of it, and then I might make fun of it. We'll see. But first, watch Ange. So yeah, we'll do that. He does. He sucks. But guys, if you've never seen my Scott song, as in my Melody Farris intro, you really need to go watch it. Or my Sarah Boone song. You need to watch my Sarah Boone song. I'm pretty pleased with my Sarah Boone song. Sarah, he said, Sarah, wriggle around a bit, he said. Yeah, I need to make fun of it. So I'll make my mind up whether or not I make fun of that tomorrow, or if we do Scott's Cross tomorrow. We might do both. Why not both? All right, that's cool. I love you all. You're all awesome. And yeah, I'll see you over in Angie's chat. Never stop singing. All right, cool. Time for the song. The outro song, that is. The outro song. Ready? Ready, Freddie? Ready, Freddie?
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud, and because she's an 803.